but let's talk about the No Surprises Act. Great. So ethical practice and compliance, No Surprises Act, good faith estimates requirements. Please keep in mind that while I am an attorney, I am not your attorney today, unless you're a client and you're out there in the audience. Hello. If you need legal advice, so I'll have to kind of stop short in terms of some of the information that I can provide today. That will be for perhaps a separate conversation, and I'll leave you my contact information at the end. Navigating the No Surprises Act, legal requirements, and ethical conundrums for mental health professionals. So first, I'd like to start with a piece that I think will help create a framework for understanding how to handle the legal, ethical, and really administrative burden aspects of putting something in place, something that we get every time that there is a new rule or a new regulation that you've got to figure out how to incorporate within the practice. My hope is to give you some information that will not take away from that provision of treatment and care to individuals in as much as possible to create the least administrative disruption. So let's look first at your practice compliance intake documentation. Let's go back a little bit and talk about your informed consent, your HIPAA requirements, primarily your notice of privacy practices, and then how that kind of dovetails into this piece that you're going to need to be providing pursuant to the No Surprises Act. So as we all know, 101, and you teach your associates now and supervisees, you must maintain documentation of compliance pre-service informational requirements. That's the stuff that you've got to get to individuals and families and any of your clients before you start seeing anyone. I know this is a very basic component, but it's very key because this is unique to mental health professionals in the provision of care. Nowhere else do we see a physician, a physical therapist, any other kind of healthcare provider where we have such a robust document at the beginning that informs the individual about all kinds of things, the type of care, what modalities are implemented, everything from that to billing and confidentiality of records. And it's a very important contract or agreement between the client and the therapist. These are the kinds of things, as we know, that you must have in place and signed and go over before the first date of delivery of care. I can't tell you how many cases over the years, both in litigation and involving board complaints, now that go before the Texas Behavioral Health Executive Council, turn on whether or not appropriate informed consent documentation was obtained, whether or not you've appropriately obtained that pertinent aspect of the divorce decree or temporary orders from the appropriate party or parties before providing care to minor individuals. So this is an issue a lot of times where several allegations may be thrown out, but if we can't find in the records that there's appropriate informed consent or a copy of the child custody orders, and that we can establish that those were obtained prior to the provision of therapy services, these often result in some level of disciplinary action in their absence. Anything you're required to inform your clients about in writing before you provide services needs to be in that informed consent. Now, I'll tell you, just spoiler alert, the good faith estimate requirement for No Surprises Act, while it is something that you must inform clients about before providing services, it's a little bit different in that it must be a standalone document. So it's not just adding a paragraph to your informed consent, nor is it saying, oh, I already give an informed consent. I already talk about these things in my informed consent. Isn't that just going to be okay? And according to the federal regulation, no, it's going to have to be something a little different. So we know informed consent's important. For example, let's look at the latest incarnation of the Texas Behavioral Health Executive Council rules. I urge you all to go on that website periodically and look. They do a great job of keeping up with updated, consolidated rule books for each of their separate licenses. And within those rule books will be contained now council rules. The council now handles all of the licensing, all of the investigation of complaints, and all of the enforcement on behalf of the boards. So when you are talking about dealing with your board, a lot of the interactions that you're having are actually with the very capable council staff. We're very excited about having this new agency that's been long in the running. It is fantastic to have an agency that's dedicated just to mental health professionals. And that makes it even better to have the folks that are protecting the public or regulating the industry, lending it integrity, and is that they are only focused on the laws and rules and practices of mental health professionals. So let's take a look. LMFT have rules about their informed consent, and those are contained primarily in their rules about technology-assisted services. Now, I will tell you in the running, I anticipate that we will have more rules. The Psychology Board addresses those. They're also part of the council. I would venture to say we will soon have council rules across the board for each of the licenses that deals with the provision of telehealth. Until we do, I really advise you all, whether you're an LMFT or not, to look at the LMFT rules that require both continuing education as well as certain informed consent content and the use of HIPAA compliant platforms. It's a really good rule for best practices, even if it doesn't apply to you, and is generally considered to be the expectations for all the licenses based on recent cases that I've had since the beginning of the council and throughout the pandemic, whenever we have board complaints and cases that involve the use of telehealth. You'll find the LPC rules about informed content and requirements here at 68141. The social worker board has their rules when it comes to general standards of practice, when it comes to informed consent. And the licensed chemical dependency counselors, while they are not continuing to remain with the council, they still have rules governing their informed consent. They remain over at Health and Human Services Commission. We talk about why these rules are really important in that there are also disciplinary actions that correspond to the failure to properly inform a client and give them proper informed consent. You will find for the LMFT, the LPC, the social workers and psychologists alike, failure to properly inform a client is a level 5 level of discipline. That is a reprimand. And that can constitute an administrative penalty of not less than $100 to no more than $1,000 per day that you failed to have that in place in the provision of services. So it's really important to make sure that that important pre-service document is in place, that it has all the content that it really needs to cover, from the type of therapy and the modalities that you're utilizing, to confidentiality, to billing, to what happens if the therapeutic relationship is terminated, and even what happens if something happens to you, the therapist, death or a disability, what happens to those records, and how might a client obtain those or continue to get services when the therapist is unavailable. And finally, make sure that you also address matters involving your litigation involvement. Those are all the kinds of things that I routinely help clients within the context of my practice. And it's an important piece. If you haven't already done so, also within your informed consent, especially now when we're going to add this No Surprises Act piece. If you haven't already done so, make sure that in your informed consent, where it is required that you give individuals information about resolving any complaints or issues they might have with you, that you have the Texas Behavioral Health Executive Council contact information and name instead of your licensing board. That's where any help or resources need to be guided. For all HIPAA-related complaints, in addition to the Texas Behavioral Health Executive Council, you also want to include the U.S. Health and Human Services and Office of Civil Rights and the Office of the Attorney General of Texas. There's a website there when it pertains to HIPAA-related issues or Texas privacy and security complaints, where the AG's office handles that, as well as there are links there to the council and the various boards. And finally, with the new No Surprises Act, you will also include the Centers for Medicare and Medicaid. There's a link, there's an email address, and there is a hotline that will be placed in your offices, on your website, and on the particular document that we're going to talk about that you need to be providing your clients now, in addition to that initial informed consent. Telehealth is another matter of informed consent. You may, unlike the good faith estimate, incorporate telehealth consent within the informed consent, or you can have it as a separate document. Either way, I recommend that you abide by the requirements of the LMFT rule for what goes into that informed consent for best practice compliance. Now, the other piece that we have in addition to the informed consent is that HIPAA notice of privacy practices. That's that really long document that none of us read. Well, I kind of do, but when you go to the doctor's office, when you're seeing the therapist, you just sign, or you sign something that acknowledges, yes, I was given the opportunity to look at this. But it's actually a very important bill of civil rights, if you will, that have been created that gives individuals, our clients, ourselves, a number of rights when it comes to our protected health information, access to that and how it is used and disclosed. And it also really explains, in addition to our confidentiality paragraphs in our informed consent, what can and can't be done with protected health information, and gives a lot of information about that to individual clients and patients. So just like the informed consent, you want to make sure you obtain and maintain signed copies of each of these things before the date of the first provision of therapy services. Even if you've got folks that come in that are filling it out when they get there, make sure that's first, that's not at the end of the therapy session. Also make sure if you're using some standard notice of privacy practices from an electronic health record provider or a colleague, something floating around the internet, make sure it's accurate and that it's got Texas specific language. Texas has some additional requirements. Texas also has some requirements that are distinctly different from the current HIPAA rule. And in those cases, the Texas law prevails over any federal law. One prime example is we have the Texas Health and Safety Code Chapter 611. We've had 611 long before the latest omnibus rule of HIPAA in 2013. And that has said forever that you must provide mental health records to an individual or a legally authorized representative with a valid authorization within 15 calendar days. That's distinctly different from HIPAA that says, for example, 30 days or an additional 30 days if you ask for an extension of time and explain why. So that's the kind of thing we want to make sure that we have in place and that we get signed before providing therapy services. So with that, let's talk about the next piece of requirements that you need to have in place before and around the provision of therapy. So the No Surprises Act that caught us all off guard. So the background story. We've got an estimated 1 in 5 Americans, according to some statistics, that have received a surprise medical bill from an emergency department visit. There's some unanticipated accident. You go to the ER, you give them your insurance. It's a major hospital. You're not really thinking about anything other than the issue at hand. You receive the care you need. You may be there a number of days. You get out, you go home, and then we have weeks and months go by, and then a bill is received in the mail that can be significant and well beyond what was anticipated, even the deductible, the copay with one's insurance. Approximately 1 in 4 Americans have received an unexpected bill when it was even a non-emergency hospital stay for something that is routine or perhaps planned, but not an emergency, a childbirth. And the idea behind this legislation is to stop that from occurring. The No Surprises Act that was enacted on December 27th, 2020 was created for the purposes of providing consumers with federal protection from these unexpected emergency room, air ambulance services, and non-emergency services out of network provider medical bills and what we call balance billing practices. This act amends several federal statutes, and the provisions of the act, as I stated, went into effect at the end of 2020, and it applies to healthcare providers, healthcare facilities, group and individual health insurance coverage offered by health insurance issuers and private sector group health plans. We've known this was coming. We talk about part 1 of the act. And so there's been a lot of focus prior to September of 21 on this legislation. Great, we understand that's going to be healthcare providers. We're looking at physicians, lab folks in a hospital setting. In part 1, we're talking about healthcare facilities and standalone emergency room within a hospital emergency department, an ambulatory surgical center, a federally qualified healthcare center, but not anything that pertains to private practice or mental health professional practice. So as of 2020, no alarm and no real idea how this might impact my licensees that are in mental health. But before we talk any more about the federal legislation, Texas first. Texas got into the act about protecting folks from surprise medical bills before the federal government did. Senate Bill 1264, passed in 2019, created a mechanism for resolving payment disputes over surprise medical bills. I think that not as many people have been aware of this. With the advent of the federal legislation, hospitals and other providers are going to have to post and provide information about both the Texas and the federal mechanisms for resolving these kinds of surprise medical bills. That law went into effect January 1 of 2020, and it prohibits balance billing for state-regulated insurance plans. So preferred providers, PPOs, HMOs, employee retirement system, and teacher retirement system, among others. This bill requires that disputes that are over out of network be resolved by arbitration instead of mediation. And it really puts the Texas Department of Insurance or an independent arbitrator as the one to resolve these disputes between health insurers and providers. And it removes the patients from the dispute and has those entities work it out to resolve any kind of billing dispute. So part 1 of the No Surprises Act. So this prohibits surprise healthcare bills. And when we're talking about emergency services provided by a non-participating provider or facility, we'll talk about what that means, or non-emergency services, same thing. There are some exceptions to the rule for some post-stabilization and non-emergency services, but basically that's what this applies to. So part 1, emergency care. Who are we talking about? Well, when we're talking about participating versus non-participating, we're talking about healthcare providers that are providing care in like an emergency department or a standalone ER, any other healthcare facility where there's an emergency service. And whether you're participating or not depends upon whether or not you've got a contract to provide services with an insurance company. In other words, whether you are in network or out of network. Just like we have with the Behavioral Health Council, we have the Texas Occupation Code and we have statutes that govern each of the licenses, and they say what licensees must do broadly. And then the how-to of what you need to follow, we find in the rules. Well, the same thing goes for the federal government. We'll have a big law, the No Surprises Act, and then we'll get rules that tell us how to follow the law. So the first rules we got were in July 1st of 2021. Again, this rule comes out and it tells us how to implement a number of the Act's requirements when it comes to emergency services. It states that the care has to be provided to the individual, whether it's in network or out of network with their insurance, and that any billing disputes are going to get resolved after the fact between healthcare providers and health insurance companies, and the federal government will be the arbitrator of how those issues are resolved. Same thing for non-emergency services. Any kind of non-emergency care you're going to get in a hospital, we're looking to see, does that provider, the lab, the anesthesiologist, the radiologist, the physician, are they in network? Do they have a contract with a health insurance plan, and in particularly the one of the patient? So the rules in July, again, just applied to those individuals. So we're not talking about our mental health professionals, other than if you had a licensed professional that was giving care, sometimes our social workers, within a hospital setting. The requirements pertain to cost sharing, balance billing, out-of-network rates, and notice to the public. When we talk about cost sharing, and this will become important for the good faith estimates for Part 2 of the bill, which does apply to you all, and why we're here today. It's talking about those things that clients pay for out of pocket. It's typically your deductible, your co-insurance, your co-payments, but it doesn't talk about the balance billing piece. Under Part 1, the government decides what the amount should be, what's reasonable, rather than just what a provider is charging or what a health insurance company says it wants to pay. Balance billing is when a provider bills a client or a patient for the difference between what they charge and what insurance will pay for. For example, if a provider is charging $100, but insurance is only paying $70, providers have billed people for the remaining amount above that, the remaining $30. This is how we get to these very large surprise medical bills. Under Part 1 of the Act and the July 1, 2021 rule, balance billing is generally just not allowed. There's some exceptions. You can have a patient agree to pay an out-of-network cost. Say there's a particular physician or provider that somebody wants, but they have to get pretty robust consent and notice about this before that kind of care can be provided. And this is where we first learn about the term good faith estimate. In fact, if you were a mental health professional who heard about the good faith estimate and were scrambling to get information about what to do, like in December, November, before the beginning of the year, most of the resources you might have found, even some of the continuing education provided, would have given you a good faith estimate form that looked like this one, that looks like the one that you would give to somebody who's trying to get out of network care in this Part 1. But that's not the part that applies to you. Part 1 also required that you put certain notices out there. Similarly, the only notice information we had at the end of 2021 really pertained to these healthcare facilities and these providers that Part 1 applied to. So that is what has created a lot of the confusion. What about this Part 1? This doesn't apply to me. Where do I get information about what to do about it? So then we get to Part 2. On September 30th, 2021, the U.S. Department of Labor, U.S. Department of Health and Human Services, and the U.S. Department of the Treasury released a second interim final rule. And this rule implements more of the Act's requirements, and it added protections for uninsured or self-paying individuals. This is where you all come in. For Part 2 of the bill, the definitions of provider and where the care is provided is a little bit different from in Part 1. Now we're talking about any healthcare provider that has a state license that is acting within their scope of practice must provide a good faith estimate to any uninsured or true self-pay client or potential client. When this rule came out, keep in mind, all of these rules have been implemented on what we call an expedited path. Rather than put out a rule, get public comment, modify the rule, get public comment, get all the stakeholders to weigh in on a rule before putting it in effect. Instead, these rules have gone in effect first, and now public comment is being accepted after the fact. That's how this caught everybody by surprise. Consequently, none of the national mental health professional councils, associations, or any of the advocates were consulted or allowed to weigh in, or were even made aware that this would be put in place prior to the implementation of this rule, January 1 of 2022. This rule imposed certain new requirements. It pertained to surprise billing. It created an independent dispute resolution process between providers or facilities and insurance issuers or health plans. It required good faith estimates for uninsured or self-paying individuals for all the healthcare licensees. It also created a patient-provider dispute resolution. If you as a patient or a client have an issue with your bill for therapy services, you may get your dispute resolved by utilizing the payment dispute resolution or complaint process now created by the federal government. And then finally, it created a health plan decision appeals process where individuals can file an appeal if a medical bill issue has to do with a violation of a requirement of the Act and these rules. First of all, the regulations put a cap on the amount of costs that an individual is going to have to pay if there's a surprise bill. The federal government is going to figure out what a reasonable cost should be and let the individual know when there is a surprise bill. The independent dispute resolution process is if you go to the CMS website and you go to No Surprises Act, if you go to the link that you all are going to put in your notices and in your good faith estimates, that link goes to a place that has resources and it has two buttons. There's a button that says, are you unhappy with your healthcare bill? Click here to file a complaint. There's a button beside it in blue that says, do you have a dispute about your bill? Is your bill more $400 or more than the good faith estimate you received from your healthcare provider? Click here to submit a payment dispute to the federal government. And as I said, there's also a process for individuals to complain or to seek help from the federal government for resolving any denial of insurance claims related to this balance billing or cost sharing. If someone gets a surprise bill, they have the opportunity to appeal through this process. So the good faith estimates that apply to mental health professionals have to do with individuals who are truly self-pay. As I said, Part 2 of the Act applies to healthcare providers who are defined as a physician or other healthcare provider who's acting within the scope of practice of that provider's license or certification under applicable state law, including a provider of air ambulance services. So yes, this does apply to you. We had a lot of question about, well, this doesn't apply to me. I'm in private pay. I'm in nonprofit. I don't take insurance. I don't deal with that at all. In fact, I got out of taking insurance to avoid these kinds of things. Well, unfortunately, I have to tell you, this does apply to you. Next, this applies to all uninsured and true self-pay clients. It requires that the regulations require that you must provide a good faith estimate upon request or upon scheduling of an appointment. So good faith estimates, or GFEs, as we call them for short, must be provided in advance of the initial appointment, just like your informed consent, just like your notice of privacy practices. The good faith estimate must include any item or service that is scheduled separately from therapy. You don't have to provide an estimate of what that might cost, but you do have to let somebody know, hi, in addition to therapy services that I'm going to provide to you, you might need some other services. You might need inpatient or intensive outpatient recovery services. You might need medication. You might need to see a psychiatrist or another healthcare provider. You might need some other services. Please know that this might be incorporated within the cost of your care. You must provide notice to clients, both on your websites and at your practice. And again, this is in addition to your informed consent. You want to implement the good faith estimate form in your practice. You will issue this to all current clients and any new uninsured and self-pay. Keep in mind that self-pay, we're not talking what we call, typically when we're talking about self-pay, we think about anybody who you yourself are not filing with insurance for. But under the federal regulation, a self-pay client is someone who truly isn't using their insurance at all. So we're not talking about the clients who get a super bill and submit for their own reimbursement, but we're talking about true self-pay, not using insurance at all. Keep in mind, in April, between April and July, there will be another rule that drops that tells you what you need to do with your insured clients or the people that are filing with insurance. But right now we need to get in place and compliance and up to speed with providing good faith estimates to right now uninsured and self-pay clients. You also must provide a good faith estimate form to potential clients who contact your practice for therapy services. This one has created a lot of ethical struggle for folks. The form requires that before you see an individual for a first appointment, or when someone just calls on the phone because they are shopping for therapy service care and they want to know about the costs, you must provide an estimate that tells the total estimated cost for services for 1 year, 12 months, and there are blanks that are required to be filled for diagnosis codes and CPT codes, even if insurance is not going to be used. This has created a lot of problems. How do I ethically and legally, as a mental health professional, tell somebody what the cost of services is going to be and what the potential diagnoses could be when I haven't even seen them yet? For folks that call on the phone or submit an email inquiry, or for folks who do that and go ahead and schedule a first appointment for themselves or for their children, that's created a lot of issue of how do I do this legally and ethically and still satisfy this requirement? Again, that gets into the legal advice specifics of how best to implement that, but those are the kinds of challenges that this creates both legally and ethically. The rule lists specific elements that are required to be in the estimate for the total cost of services. This estimate has to be in writing, even if you go over the information on the phone or in session. The estimate has to be required in accordance with specific timeframes. You have so many days after a potential client calls you, so many days after a client schedules appointment and comes to see you, that you must provide them with this estimate. Also, the good faith estimate becomes part of the mental health records, just as does the informed consent and the notice of privacy practices. So you want to keep that within the health record. And this will be, again, a situation where state law prevails. You will keep this in your records, not 6 years as required by the federal government, but 7 years or 5 years from the age of majority, which now the council has streamlined and keeping in consistency with the Texas Family Code for all licenses. That's the record keeping retention that applies. The rule also, as I've stated, creates a process for disputing bills that are greater than the expected charges in the estimate. So if you give someone an estimate for services, but later you end up charging them more than the estimate given, a client can begin a dispute resolution with you by accessing the CMS website and filing a dispute through the portal. And when they do that, there's going to be a third-party dispute resolution organization that's approved by the federal government to review the good faith estimate and the bill and any information that either you submit or the client submits to resolve it. Then the organization will determine if the additional charges billed were allowed, or if the provider may only charge what was in the GFE or some other amount lower than what's on the invoice. Finally, something that's very important is complaints and enforcement. Very important to know that in addition to payment disputes, clients have the ability to just file a complaint in general with the federal government about anything related to the bill. So this act empowers both the federal government and the states to enforce compliance. So while there's already a link on the CMS website, what you need to anticipate is that we will see complaints filed with the Texas Behavioral Health Executive Council, the Health and Human Services Commission, the Texas Department of Insurance, and or the Office of the Attorney General. These are going to be the agencies most likely charged with enforcing this law. Already on the books, you have Council Rule 882.36 other laws, and it says that licensees must comply with all applicable state and federal law. So even without a specific rule on the books yet about No Surprises Act, you'll already required to comply with this requirement and this law, and the council can enforce that. So ethical considerations, some of the things that we're talking about again are giving an estimate to somebody before you see them. How do we tackle that? Maintaining records of potential people who call in, who are first, we figure out if they're uninsured or truly self-pay, and then sending them a good faith estimate, even though they won't go into the electronic health record, and how to keep up with that. Because that information is protected health information, even if someone doesn't become a client, and we're required to keep up with and maintain that documentation of that interaction. Another ethical consideration that's out there that we hear a lot is, wow, this is really going to be a hurdle for folks with getting access to care. You know, it's already hard to get folks to seek the mental health services that they need. And while telehealth has really helped folks get that care, wow, if they get a big total estimated cost for the year, that might be a big deterrent. Also, this creates an administrative burden. Wow, you've got yet another thing to keep up with your practices. In fact, many of these concerns have already been voiced in a January 25th, 2022 letter that was sent to the federal government and signed by all of the national organizations, counseling, social work, AAMFT, psychiatrists, pick a thing, that have all asked the government to please not make this law apply to mental health professionals or to change it in some way that it's less burdensome. I don't anticipate that that will happen. I do anticipate that we may see some changes in the requirements along the way. And as I stated before, right now, this only applies, the piece of it only applies to uninsured and self-pay clients, true self-pay to you all. But between April and July, we'll get another rule, and you will have additional requirements pertaining to folks that are insured, and that includes folks that submit claims on their own. And with that, I will open for questions, and here is my contact information as well as that of my firm.
Awesome. Great information. Wow. Let's see. Sharon asked, does this mean that we have to verify insurance coverage even if we don't take insurance and bill at their rates?
It means that, yes, you must ask your current clients right now, even people you've already been providing services to, and potential clients. The regulation says you must make a determination by inquiring. Do you have insurance? Are you using it? Are you going to use it? And you have to figure that out in order to then make a determination about whether to send them a good faith estimate. As far as the rates of insurance, you don't necessarily have to use the insurance rates. You give them what your rate is and what the estimated cost would be if they got the average year of services from you, and to indicate what your services are, whatever it is that you charge.
And Marta asked, what about all the people that have been providing services prior to this meeting?
So everybody that's been providing services, say since January 1, but let's be clear. Most everybody is not in compliance right at this moment. In fact, I get an email every so often where they say, well, I heard that they're deferring enforcement until next year. No, that's not true. They're deferring enforcement on the insurance piece because they haven't put the rule out yet. But right now, everybody could get a complaint. If you go to your dentist, if you go to your doctor, if you go to any of your healthcare providers, I'm going to venture to tell you most of them are not up to speed on this, and they're not providing the good faith estimates yet. But think about this like the notice of privacy practices. You remember, now everybody gets a written copy before you go in. But it used to be back in the day, people didn't. And even after the requirement went into effect that mandated that you get a written acknowledgement of receipt, it took a while for healthcare providers to, one, go, this is really a thing and I really have to do something about it, and two, to comply with it. So keep in mind, you may have folks out there that are reticent, that are not complying. One of the things that is a positive for mental health professionals is you all are always the first people on the forefront of wanting to be in compliance and to be ethical. And January 5th, when CMS had a stakeholder meeting, the very first question was from mental health professionals, all about this good faith estimate and how to be in compliance.
And Sharon actually added, isn't that balanced billing, I guess, for her previous question?
Isn't balance billing. So, okay, let me see if I can understand that. It's not balance billing if you're going ahead and telling people up front, this is what my services cost. This is what it's going to cost you, letting you know ahead of time before they consent to therapy services. What happens with balance billing is they charge more than, like, you have no idea. You think your insurance is going to cover it, and then you get a bill for more than the insurance, and you didn't get any advance notice or ability to agree to that. That's the difference.
Lauren and Sarah, do y'all have questions there at the office?
I have a question, and I'm sure some more people might. Amanda, it says to provide the good faith estimate upon scheduling, but a lot of potential clients, when we schedule them, are not in our online portals yet. We can't send them records electronically through the medical system that we're using. So are we supposed to email them a good faith estimate, and then isn't that not in compliance with HIPAA?
You just hit one of the biggest ethical and legal conundrums. Bear in mind, the same regulators that are enforcing this regulation are a lot of the same people who enforce HIPAA. So what's happening now is you're having to create a separate record keeping system outside of your electronic health record that is a means that you keep up with potential clients that haven't scheduled yet, who are giving you essentially protected health information, and you're providing them with an estimate, and you've got to have a way to do that securely. What that is going to look like, most likely, is a separate encrypted email system where you send this good faith estimate to them. You can also fax or mail these to them. The rule contemplates that several healthcare providers will be spending a lot on postage to mail out good faith estimate forms to clients. But I recommend that you get a separate encrypted email system and come up with your own way to keep up with those potentials. Also, please keep in mind that in Texas, we have broad privacy and security laws that apply to a lot of people, not just healthcare providers, that requires that you maintain and keep that information protected and secure, because it's protected health information, even if these people aren't your clients yet.
Okay, so a follow-up question to that is, what about potential clients who haven't scheduled with us but are looking for information? I know most of us post our fees on our website. Can we also put a generic good faith estimate on our website for people to access?
So no, no, you can't put it in the informed consent. Right. And then the corollary question is, well, if I can't put it in my informed consent because it's potential, can't I just put it on the website and then everybody can see it? Now, the regulation really requires that you specifically get the information from the people, because keep in mind, you've got to figure out whether or not they are self-pay or uninsured. And to do that, and to fill out the form, you're going to have to get their name, their birth date, some contact information, and whether or not they're using insurance. So that's going to have to go on the form specific to each individual potential client inquiry. And then you're going to have to send it to them individually and maintain a record of that.
Lauren, I got a follow-up on that.
Yes, we have a follow-up.
What's going to happen to more than one agency? Bios on it, their prices, their insurance, right? But they don't control the website, somebody that owns their renting space or whatever. And the other part, what about Psychology Today?
So he's asking how this applies to Psychology Today and therapists who work for agencies.
Okay, so you've got to put it on your website. So if you don't have control of your website, or you only use Psychology Today and you don't maintain a Facebook page, a website page, you've got to figure something out. One solution may be to get your own website page. Another solution is to go to your practice and say, hey, we really need to comply with this. Let's get this notice up on this agency website because we need to, because the federal government says it's a thing. I don't know that you're necessarily going to put it with Psychology Today unless that's the only thing you use. And if that's the only thing you use, you may have to have a conversation with them about how best to accomplish this.
And when you say place it on your website, you mean the link for the center, the CMS, the Center for...
So there's a website notice that the regulation requires that you put up. It has certain language. It says certain things in certain fonts. And that's where we start getting over into my legal and ethics, where the nuts and bolts and the specific becomes the provision of legal advice. And so I got to stop short of that, but call me.
Yeah. Anyone else have questions, Helen?
Right, number one, I see something up there. Where did we obtain this form? But when it comes to the good faith estimate, are there any forms that are already created that are usable and compliant with all the laws and regulations?
There are, if you Google, a number of things out there, just like there are for anything. You can put it on the web. CMS has provided a model notice. It has some of the requirements, but it actually doesn't have all of the requirements that are listed in their own regulation. I've got some documentation that I've put together. I'm happy to, after this, take a call, email, and talk to you about how best to get good, accurate information and get it in place.
We have a few
Yes.
more.
Oh, go ahead.
A few more for our online folks. Let's see. Jenny, and I think Carrie's questions are similar. Do we need to provide a GFE for a year's worth of services, even if the client doesn't need a year of services? And then she's also asking, where do we obtain the form?
Okay. Yes, you've got to give them an estimate for a year's worth of services, even sight unseen. Now, after you see the clients and you have the opportunity to ascertain their needs, that good faith estimate may change. But initially, that is what you want to strive to accomplish, is to provide them 12 months worth of services. As far as the form, again, contact me and let's talk about where you might best get those resources. And I see if I give an invoice, I can't know if they submit to insurance. For those of us who are fee for service only, what do we do? So keep in mind, part of the regulatory requirement, the very first requirement is make a determination by inquiry. So you've got to ask the potential client, the current client, the new client. You've got to find out, hey, do you have insurance and are you going to use it?
So as a follow-up to that, Amanda, I have some clients who wait until after they've been seeing me for 6 months and then they're like, oh, I'd like a super bill so I can do out-of-network reimbursement. So with those clients, wouldn't it make sense to do a GFE anyway and just assume that they're not going to do that? Like, would it be better to be safe than sorry and just?
You can make sure though that you've made the inquiry, just like you do on an intake documentation. It's just another piece of something that you find out. And if later you find out after the fact and you had no idea, once they tell you, now you know, and you may give them an estimate.
Cynthia has.
So as far as, the good faith estimate, you think your fees for what your, potential client is gonna possibly use you for however long? What about no-show fees? Because I've had clients dispute no-show fees.
So our no-show fee is supposed to be on the good faith estimate.
So that is one that we are calling in our firm uncharted territory. These are the kinds of things that weren't contemplated, because if you think about it, we've been talking about emergency rooms and physicians and different things where where the rule is silent about what about no-show fees? What about the fees that I charge if I'm dragged into court unwillingly? What about a number of things that the regulation right now is just silent on? And so that's where I can, call me, we get into the legal pros and cons of how best to address that.
David, did you have a question too?
Yeah, let me.
Okay, we're gonna pass on that one.
So I see a couple of things. What is our liability for pre-meeting diagnosis? That's one of the ethical conundrums we have. Do you comply with the estimate and come up with some kind of diagnosis, or, and how could you do that without seeing someone? We're working on navigating that. Are we only on the hook for this if they sign the consent form? No, because we've got potential clients. The idea is the positive of this law is to create the ability for consumers to shop for their healthcare like they do for other things, and to get estimates and to make a determination about where they're going to go based on those. So that's going to apply to the potential. So if I do not take insurance at all, I make the inquiry, but let them know if you choose to use insurance, I cannot provide those services. That's a little bit different. I'm not sure I understand that question. You may see whomever you want to see. Whether or not they use their insurance is really kind of up to them. Should the relationship be in place first, like a real estate contract? What if you're wrong, depressed, then suicide? These are some of the struggles that we're having with the estimate, trying to quantify healthcare like we do a knee surgery, which is the example that's given in the federal comments. where they talk to you about somebody's got a knee surgery, what the diagnosis codes and the CPT codes are for that, what the total estimated cost is likely to be, because it's more easily quantified. What's difficult is these rules really didn't contemplate mental health services.
So Amanda, if I could add in a comment about the diagnosis, and I know you can't give legal advice, but I'm just going to share with the group what I saw in a sample GFE is that some people listed here are the most common diagnoses I give in my practice. And they listed the most common ones so that most likely the person coming would hopefully fit under those. That's one way I've seen it handled.
There are some different ways to handle that. And again, I will save that for some one-on-one consultation. And with that, you all have my contact information. I have really enjoyed the opportunity, and I'm going to scoot off to court.
Thank you, Amanda, so much.
Great information.
Thank you all.
Thank you.
Take care.
You too.
Lauren, do you have any updates for upcoming meetings?
Well, we're gonna have one next month, the third Thursday. It'll be much more informal and like we usually do, where we just introduce ourselves and hang out for a bit and network. Does anyone have any announcements for today, like upcoming trainings or CEUs or workshops or? Yeah.
I think Grace Counseling is starting their CEU events in Fort Worth. It's in White Settlement at the Region 11. I went a couple of years back, and it's a really great way to get like CEUs for half the evening. One problem is just on Thursday, so.
Okay.
Do
they have a website, or how do you know about this?
Excuse me, on Thursday. I think they once did it on Fridays. That was great. So I'm booked on Friday. So
yeah.
Thursday.
Okay.
And they bring in some really informative speakers.
Yeah.
Yeah.
Okay. Any other announcements or questions? Yeah.
Yeah, and I had mentioned this before and you forgot also.
Oh, I added it to one of the announcement websites.
Yeah,
Yeah.
bracelets, here's an example. But basically, I'm getting them for some of my depressed clients, and I've got teens and I've got young 20-somethings. And I just feel like it's really helpful. I'll pass it around. What it is it says I am enough. And she can make it in all different kind of bead colors. But it was woolen designs.
I actually did this last, and I never heard from them.
You mean you submitted an order?
Yep.
Well,
Sure did.
I will check with you.
Okay, right. Get matched it, like a coffee. Yeah.
Thank you. Oh,
Yeah,
like the
that's
coffee.
nice.
Do you want me to
I'll
add a
over.
link again in this
Yes,
announcement?
yes.
Okay.
Yeah, I wanted one.
She's given me like, I've gotten 6. And I kept that one. If I had worn it yesterday, I probably would have given it away. Because the young lady always really likes turquoise.
Yeah.
Anyway, I
Okay.
just thought it was really cool because
Yeah.
it helps to remind them that they're important and somebody thinks they're
Wear that out.
Yeah.
I
Chris
have a
cuts it.
announcement.
Yes.
I'm Emily Green. Samantha and I office out of the Mending Clinic in Arlington. And my husband and I are going to be doing a virtual CEU on March 4th about healthy lifestyles and how nutrition, movement, and sleep can interact with mental health. Also,
Could you send me a link for that so I can include it? Okay.
Also, too, half of you already know this, but
Thank you.
my name's Katie Walker, and I'm the president of the NFT, the Fort Worth Area Association of Marriage and Family Therapists. So you don't technically have to be an MFT to come to these meetings, but they are the third Tuesday of every month. So if you really want to network a lot on the third week of every month, you can come to our meeting and then to this one. So
That's at Old
it's
South.
at Old
right?
South Pancake House.
Oh,
Yes.
wow.
Yes.
That's Susie's.
And if you come for the first time, we pay for your breakfast.
What?
So, yeah. So
When
come on over.
when we just had our last meeting, I asked
2 days
you,
ago.
I asked you about the picture exercise.
Yes.
And you said you see everybody will get one but me. I
Yeah.
didn't get one yet.
Well, I told you wouldn't get it. I'm kidding, Michael. I'm actually haven't gotten it from Laura yet on the forwarded to me.
Thank you. Ron.
Only to you.
Only to me. What about him? He's important.
Hey, Lauren.
Yes.
Okay, great.
there was one thing I thought about in all of this that we're talking about today, and that was, how many people take EAPs. EAP fees are not something for the client to be concerned with because they're paid things.
Oh,
So
yeah,
there's a lot of things that get covered, I guess, in that
that's a
process.
good question. Yeah, I don't know if a GFE would apply to that.
But I still take an intake form, I still do the informed consent,
Yeah.
so.
Yep, it's a process. There's still quite a few people online. Did anyone online have any announcements? I don't see any. Okay, Eric, if you can still hear me, thank you so much for hosting this. We really appreciate it. I think everybody in the group still needs a link to do if you want your CEU credits, make sure that your email is on the list, the sign-in sheet, so that we can send you the link for the evaluation to get your CEU, right?
Yes, we'll send that out tomorrow, and also a link for the recorded presentation on YouTube. So
Okay,
thanks
thanks,
for
Eric.
letting us join you.
Yeah, I appreciate it. Have a good day.
Blessed weekend.
Bye.
Bye.